First, welcome to our deep dive on navigating the L-1 visa trap when administrative processing hits. Next, we will outline what administrative processing means, why it happens after an L-1 blanket interview, and how to pivot strategically. Finally, stay through the end for key takeaways, a couple of quick quizzes, and a practical action plan. First, here is the agenda. Next, we will define administrative processing and why it often follows an L-1 blanket interview. Then, we will compare waiting versus pivoting and outline the individual L-1 petition strategy with evidence checklists and timelines. Finally, we will finish with quizzes and key takeaways. First, we set the stage. After an L-1 blanket interview, many applicants receive a 221G administrative processing notice. Next, this delay can feel neutral, but can become a serious career and business risk due to uncertain timelines and closure deadlines. Finally, we will address a concrete strategy to minimize risk. First, a disclaimer. This content is educational and not legal advice. Next, immigration outcomes depend on your specific facts and the latest regulations. Finally, you should consult a qualified immigration attorney for tailored guidance. First, administrative processing under 221G is technically a refusal, pending additional review. Next, it has no reliable timeline, which means it could be quick or take months. Then, in L-1 blanket cases, this frequently indicates the officer was not convinced that the applicant meets the strict specialized knowledge standard, or that the documentation was insufficient. Additionally, prolonged uncertainty becomes a business liability if the current office is closing or deadlines are imminent. Therefore, a strategic pivot to an individual L-1 petition is often the most prudent move to front-load robust evidence and regain control. First, the L-1 blanket interview places the eligibility determination squarely on the consular officer during a short interaction. Next, applicants often carry limited supporting exhibits under the blanket program, creating thin files. Then, any ambiguity around specialized knowledge invites administrative processing. Additionally, if the company is undergoing restructuring or office closures, the risk of delay has outsized operational consequences. Therefore, it is essential to remove ambiguity through a more comprehensive evidentiary approach. First, this flowchart starts at the L-1 blanket interview and asks whether a 221G administrative processing decision was issued. Next, if there is no AP, the visa is issued and the process completes. Then, if AP occurs, the timeline becomes uncertain, introducing corporate deadline risk. Additionally, a decision node presents two options: wait or pivot. The wait path is marked as high risk due to indefinite timelines. Meanwhile, the pivot path instructs to file an individual L-1 petition with USCIS, optionally using premium processing. After USCIS approval, there is a new consular interview supported by strong evidence. Finally, the outcome could be issuance or a need to reassess, but the pivot significantly improves odds and control over timing. First, waiting appears simple but does not address the core evidentiary gap, leaving the timeline fully uncertain. Next, by contrast, pivoting to an individual L-1 allows the employer to build a comprehensive record with detailed proof of specialized knowledge. Then, premium processing can compress USCIS adjudication into 15 calendar days, restoring predictability. Finally, the pivot provides a stronger foundation for the subsequent consular interview, reducing ambiguity that triggered the blanket refusal. First, this table compares three paths. Next, waiting on AP has no immediate cost but carries an unknown timeline and operational risk. Then, filing an individual L-1 with premium processing offers robust evidence and faster USCIS decisions at a higher fee, with a typical 4 to 8 week end-to-end timeline including interview scheduling. Finally, filing without premium processing lowers fees but extends the USCIS stage to several months depending on workload. First, alert leadership to the risks of waiting under AP and emphasize deadline exposure. Next, obtain authorization to file an individual L-1 petition using Form I-129 with the L classification supplement. Then, consider premium processing to shorten USCIS adjudication to approximately 15 calendar days. Additionally, assemble a comprehensive evidence package using the checklist we will detail. Meanwhile, maintain tight communication among HR, legal counsel, and the business unit to coordinate dates. Finally, prepare for the new consular interview using the USCIS approval and curated exhibits to clearly present specialized knowledge. First, clarify the role with a duty breakdown and explain why the candidate is not easily replaceable. Next, document proprietary knowledge, including systems, tools, code bases, or workflows that are unique to the employer. Then, quantify impact with metrics such as productivity gains, cost or time savings, and reduced risk. Additionally, provide organizational context through detailed org charts and reporting lines. Meanwhile, build project narratives that connect past deliverables and future roadmap to tangible business outcomes. Furthermore, include corroboration through manager and expert letters and, if permitted, client attestations. Also, visuals such as process maps, architecture diagrams, SOPs, and training plans help the adjudicator understand complexity quickly. Finally, consider drafting a concise specialized knowledge summary in Markdown format to align stakeholders before formalizing exhibits. First, here is your quiz question. Next, the options are: wait for AP to resolve, file an individual L-1 with USCIS and consider premium processing, reschedule the same blanket interview, or switch to a visitor visa for work. Then, you may pause the video now to think about your answer. Finally, we will discuss the answer in the next section. First, the correct answer is to file an individual L-1 petition with USCIS and consider premium processing. Next, this strategy allows the employer to present comprehensive evidence and reduce ambiguity, addressing the reasons that triggered the blanket refusal. Finally, it also restores predictability by leveraging premium processing timelines. First, the administrative processing path features an unbounded timeline, which limits planning. Next, the individual L-1 path has predictable stages, and premium processing can reduce the USCIS decision time to about 15 calendar days. Then, coordinate interview logistics early by preparing medicals if required, updating the DS-160, and aligning travel windows. Finally, manage expectations by informing leadership that communications will follow a two-track approach until a USCIS approval is secured. First, here is the second quiz question. Next, the options are: too many pages of evidence, officer uncertainty about specialized knowledge or insufficient documentation, paying the fee in cash, or wearing casual attire. Then, you may pause the video now to consider your answer. Finally, we will discuss the answer in the following section. First, the correct answer is officer uncertainty about specialized knowledge or insufficient documentation. Next, ambiguity at the interview stage is a common reason. Blanket cases are refused under 221G, pending administrative processing. Finally, this is why a robust, front-loaded individual L-1 petition helps clarify the record. First, this sequence diagram outlines key stakeholders: the applicant, HR or the manager, Immigration Counsel, USCIS, and the consulate. Next, the applicant alerts HR about the 221G decision. Then, HR engages counsel, who prepares the I-129L petition. Additionally, USCIS receives and adjudicates the petition, with premium processing as an option. After approval, the applicant updates the DS-160 and schedules a new consular interview. Finally, the consulate considers the USCIS approval and either issues the visa or requests further action. First, administrative processing is a 221G refusal with uncertain timing. Next, blanket refusals often reflect ambiguity regarding specialized knowledge. Then, waiting poses significant risk when corporate deadlines loom. Additionally, pivoting quickly to an individual L-1 with robust evidence is the most effective countermeasure. Furthermore, premium processing can restore predictability. Finally, align stakeholders early to keep the transfer on track. First, we defined administrative processing and its risk profile. Next, we explored why blanket refusals occur. Then, we recommended pivoting rather than passively waiting. Additionally, we outlined how to build a persuasive individual L-1 record. Furthermore, we leveraged timelines and premium processing to regain control. Finally, we prepared for the next interview with a stronger case. First, thank you for watching. Next, if you found this guide helpful, please like the video, share it with colleagues, and subscribe for more strategy-driven content. Finally, Tell us your experience with administrative processing and what pivot plan you are considering in the comments below.